Welcome, everyone. We're going to get started in about a minute or so. Just want to let folks enter into the webinar. Hope everyone is having a lovely day today. Again, we're going to get started in about a minute or so, just letting folks enter into the webinar. I will also be posting the link to this PowerPoint in the chat in case anyone missed it on the email that went out this morning. We'll get started in just a little bit, maybe about a minute or so as folks enter into the webinar. We'd love to know where you're joining us from. If you want to put in the chat where you're joining us from the webinar, we'd love to see where our attendees are coming from across the nation. We've got someone from Indiana and Minnesota. Welcome, Evelyn and Adam. Eastern Shore of Maryland. Love that. Ohio, California, Vegas, Kansas, another Indiana, Tennessee, a couple Tennessees, New York, Connecticut, Washington State or DC, unsure. Atlanta, welcome everyone. All right, so it seems like we've got a good amount of folks, so I'll go ahead and get us started. Just welcome everyone again to today's NAEA quarterly GR update with our guest speaker, Timothy J. McCormally, the special counsel in IRS's Office of Professional Responsibility. Please note that this Zoom webinar is being recorded. My name is Erin Mosier. I'm the Director of Education and Events here at NAEA, and I'll be your technology moderator for today. So if you have any technology issues with your Zoom, you can go ahead and put them in the chat. I'll be monitoring that throughout. Oh, I love seeing where everyone is coming in from. Keep putting it in the chat if you haven't already. Just a few housekeeping items before I kick it over. If you have any questions for our speaker today, please use the Q&A box found on your Zoom client. We have enabled the upvoting feature. So if you see a question in there that someone else has posed and you want to make sure it gets asked, there's a little thumbs up sign on that question. You can go ahead and hit that and we'll make sure to get those first. And we will only be taking questions from the Q&A. So try to put them in there and not in the chat just so they don't get lost. Remember when making a comment in the chat that everyone can see it. So please be respectful to your fellow learners and use the chat to share information and ideas regarding the presentation. If you require closed captioning for this webinar, you can click the Show Captions button on your Zoom client and then hit Show Transcript. All right, so that's all the housekeeping I have for today. So I'm going to turn it over to Thad Inge of Van Scoyac Associates, who is on the NAEA GR team to get us started today. Thad, it's all yours.
Great. Thanks, Erin. Really appreciate it and appreciate everyone joining today from all over the country, it looks like. We are really excited to have Timothy McCormally with us today. Not only is he with the Office of Professional Responsibility, which plays a very important role for everything EAs do, but also has a long history in the tax world and knows a lot about tax administration and all things IRS. And so he's just a wealth of knowledge, and we're excited to have him with us today. Timothy McCormally joined the IRS's Office of Professional Responsibility as a special counsel in February 2021. And from September 2022 to April 2023, he served as OPR's acting director. Previously, he served 7 years as a director in KPMG's Washington National Tax Practice, 30 years with Tax Executives Institute, both as general counsel and executive director, and 6 years as a tax associate with the predecessor of Evershed Sutherland. Timothy received his bachelor's degree from the University of Iowa and his law degree from Georgetown University Law Center. He is a frequent speaker and author on topics of tax ethics and professionalism. Has published a book of poetry. Maybe we'll get to hear a little poetry thrown in today as well. And served 4 years on the Internal Revenue Service Advisory Council, including 1 year as chair of the overall group. He was nice enough to join us from beautiful Maine today, which you can see in his background there. And just really excited to have you with us today. So welcome, and I will turn it over to you. As Aaron said, we will do some Q&A. Put them in the Q&A. Most of them will probably hold till the end, but a few we might sprinkle in throughout the presentation. And thanks so much.
Hey, thank you, Thad. It's good to be with NAEA today, and you know that I am. If I can get the slides to advance. Weird. All right. I'm going to take a slightly different approach to my comments today, and part of it is marrying my prior experience of 30 years with an organization very much like NAEA in that it's tax oriented and it's membership driven, and talk about that and talk about my experience working with OPR and how the two fit together. And you know, it's always good to have a better title than you have comments. So the title I included the name de Tocqueville, and those of you who probably paid more attention in college than I did would know that Alexis de Tocqueville wrote a book called Democracy in America. I think it was published in 1835, and despite my appearance, I wasn't around then. Interestingly, de Tocqueville was in France, kind of padding around his house, and his mom said, "What are you going to do with your life?" He didn't know, so he in effect wanted to take that year abroad, and for him it became about 5 years abroad, and that was in the United States. And he went all around the United States, and he talked to people, and he listened to people, and he watched what people were doing. And one of the things that struck him as different from the way things were in Europe is the large number of people who banded together voluntarily to try to obtain something collectively that they could not do themselves, whether it was advocacy or education or networking, and so it fits very much, and how I found this out was once I became the executive director of Tax Executives Institute. They said you should learn something about associations generally, and he's like a patron saint in the association world, because isn't that what we are all about, whether you're NAEA? And actually, if you're in a big organization, as I am now with the IRS, the whole idea is collective action. We get smarter when we crowdsource things. And the interesting thing, to go back to the Tocqueville for just one more moment, is that his model that he cites in the book were temperance unions. And so I used to joke, because TEI was founded by somebody who worked for a distillery. But even if you just work in the tax area and not in a distillery, you might find the whole idea of your predecessor, your genesis lying in people who were all about convincing other people not to drink or not. In any event, the whole idea of collective action is something that NAEA knows a lot about, and what does that collective action mean? So this is all stuff that I took from your website, so it is stuff that you know, but we're going to break it down and talk about the intersection of what you guys are advocating for or doing, and what OPR is responsible for enforcing. Those words: empowering, educating, advocating, and connecting. And so I think that the idea of sharing what we do and sharing what we're concerned with about others with others is a way to feel better about ourselves. We are not alone, but more, we gain insights from those others, and are able to accomplish ends that we could not do ourselves. And so the network is probably the first thing. I often said, when I headed TEI's advocacy effort for 20 plus years, that is not why people joined. People joined so they could be in the collective room together, whether that's a Zoom room, or that's at a conference or a seminar or something like that. I often say the most valuable person when you go to a program that NAEA or TEI or another organization does is not the person speaking, the person on the dais. It's the audience. It's the person to the right of you, or to the left of you, or in front of you, and behind you, right? Because you can kind of say, is that how you do it? That doesn't make sense to me. That does make sense to me. Do you have any experience with it? That networking is what not only binds us together from a social standpoint, but from a professional standpoint. But the other thing we do is we, as association members and as people who intersect with associations, is we engage in educating the members. And then the third thing is educating others, the people outside, whether they're government or in peer organizations, in terms of what we are advocating and why we are advocating it. We're sharing that information. So networking, education, and advocacy is what undergirds almost every professional association that I'm aware of. And it's something that I would encourage you in a way to kind of step back and say, gosh, we are doing a lot of things. Here you're on this government affairs call because you are interested and concerned about legislation and regulations and other things that affect the EA community and the tax community more generally at a policy or an administrative level. But a hidden benefit, I think, beyond, hey, I got to solve a problem for my practice or for a particular client, is that the opportunity that membership in a group like NAEA and any of its committees or on its board of directors or trustees, is that if you can encourage and successfully manage and lead a group of volunteers, you could probably take those skills and that experience and apply it in all aspects of your personal life and your professional life, in your firm or things of that sort. So I think it's a hidden benefit that maybe as we're trying to encourage people to become more involved, that we neglect to mention. And so I just would encourage you very much to do that. And I'll give you this one example. I did serve on the IRS Advisory Council for 4 years, and for 3 of those years, I had the opportunity to meet and know and work with Jennifer McCormally, who's very active in NAEA, and in fact, I was honored to serve as her vice chair when she was chair of the group. And what you probably all know is those late night emails and Saturday afternoon calls. You do it because you made a commitment to do it, but you do it also because the people that you have the opportunity to work with, to learn from, are just an amazing group of people. I left that experience from having lots of conversations with Jennifer and other people, quite candidly, with a much better appreciation for what the EA community puts up with. For the bulk of my career, I either represented large corporations one-on-one, large corporations, as a group at TEI, and the in the weeds aspect that EAs are required to engage in every single day on behalf of their clients is something that's quite candidly beyond my kin and my ability to do. And when I moved over from a Big Four accounting firm to OPR, in a way, I got to take a step back and say, all right, now, what are the standards in which we are applying to practitioners, whether they're EA or accountants or attorneys, and what are the lessons that we can apply and the information and insight we can share. So I was thinking about what this means in particular with what the core responsibility of OPR is to enforce, and that includes a big component of education, right? Making people aware of what their obligations are, to enforce Circular 230. And there are at least 4 provisions, and you could probably say every single provision of Circular 230 where an individual tax practitioner, whether an EA or other another professional, can gain insight into and get assistance from their peers, and that's due diligence. How do you know what is required of you? Well, you look at other people that it's required of. You see how they respond to the challenges, to the opportunities, to the disasters that invariably come up. And by sharing those experiences, either one-on-one or at a conference or a Zoom call like this, all of a sudden you gain some wisdom that allows you to say, this is what due diligence means in this standpoint. Similarly, by going to NAEA or other tax conferences, we build ourselves up and our competence up in terms of what we're doing. I was just reading, I guess it was this morning, the whole issue of what does artificial intelligence and chat GPT mean to tax professionals? You know, and can you outsource your responsibility to someone else? And I like to say, you outsource the responsibility for delivering a tax return or a protest or another document to the IRS by giving it to the FedEx guy or taking it to the post office and sending it by certified mail, right? You can't outsource the obligation you have in undertaking that step to communicate, to share what your work product to someone who does not respect and will not follow the obligation we all have to safeguard taxpayer client information. Our duty of confidentiality does not end when we put it in the outbox. It does not end when we upload it to the cloud, whatever it is. And so by interacting with one another, excuse me, we can in fact gain insight into that. My favorite provision of Circular 230, and I'll be honest, I did not think about it, at least as a provision of Circular 230, before I joined OPR. And that is section 10.36, which says that if we have a leadership role in a tax practice that is subject to jurisdiction of OPR, so we have a leadership role in that. Our job is not only to make sure that we are competent, that you are competent, but that all the people who are engaged in that practice for you, and that, to go back to my FedEx delivery person, or the IT consultant, or even the janitorial staff that you might have, that it doesn't matter if they're a non-tax professional or not, people who help, who are cogs in the machine of an EA's practice. And maybe it's a one-person machine, and maybe it's a 10-person machine, or maybe it's much bigger than that. That our responsibility as a leader is to make sure that every single person in the practice who supports the practice is aware of their obligation and have the means by which to meet those obligations. I like to say that there are three things that those of us who have a leadership responsibility must know. One, do we have standards? Two, do we monitor compliance with those standards? And three, if there's a deviation for those standards, do we have procedures to remediate the situation, to make them better? My example, and she was a CPA. I don't think she was independently an EA, but if you go back a couple of years ago, the former lawyer and campaign official for President Trump, a guy named Paul Manafort was charged for violating the tax laws, both in respect to FBAR requirements and income tax conclusions, and he spent some time in jail for that. But let's not talk about him. He had an accountant, and that accountant worked up based on the numbers that were provided to her by the client and by one of the client's assistants, to say, hey, this is what your tax obligation is in this particular year. And perhaps this has happened to you. I know it has happened to me, that when you present the client with the ugly truth of what their activities the prior year leads to in the tax return you're going to file this year, they were a little concerned, both Mr. Manafort and his assistant, who had a similar obligation with and said, what can we do to manage the tax liability? And so the CPA, as she later testified, because the client was such a good client to the firm, postulated that if a particular payment or a set of payments received by the client were not payments for fees, but rather were loan proceeds, then that amount of those funds could be excluded from income and the tax liability would come down. And during the Manafort trial, she was on the stand, by the way, granted immunity, and they said, why did you do it? And he said, because the client was such a good client of the firm. Okay, so that case is over. That case goes to the jury. The jury finds its verdict, which in this case was guilty. Let's say that was a Friday. On Monday, the accounting firm fired her. And you go, well, gosh, that's, she testified under a subpoena. Why did they do that? And they said, well, the firm had standards. The firm may have failed to monitor compliance on a real-time basis with those standards, but having discovered a deviation from those standards, it had to take action to remediate the situation, and so they dismissed her from the practice. And if they had not done that, my guess is, and she was a Virginia accountant at the Board of Accountancy in Richmond, would have done it too. So those things happen on an individual basis, but also our responsibility as someone who is the head of the practice is to make sure that they are satisfied. All right, so let's talk about what NAEA and OPR do together. And my view is, and you know this, right, that enrolled agents are an indispensable partner of the tax administrator in enforcing and administering the law, right? I mean, that without you guys, a lot of people would be up the creek, and one of those people would be, in fact, the tax collector. Lots of responsibility is outsourced to you. But more than that, NAEA as a collective, as a group of practitioners who have bound together, as Alex de Tocqueville observed that you would, and you come into the IRS, to OPR, or to other agencies and say, hey, we've got a bigger view than you have. We have a different view from what you have. Let us share that view with you. From OPR's perspective, our job is to say, hey, NAEA, is there a way that we can help you educate your members by asking folks like Tim McCormally, or maybe people who are much more qualified than I am, to come and talk about how particular rules apply. And so there's a symbiosis, right, that we benefit one another. And I think that this, in my short period of time, not just as a member of OPR staff, which is 3 years before the 6 months I spent or 8 months I spent as acting director, there are a number of examples where we work together directly, or we work together on parallel paths that are all about improving the lot of enrolled agents and the federal fisc, but also tax administration generally. And those four items at the bottom of this slide: return preparer legislation, where NAEA has been one of the upfront and consistent supporters of that legislation, is one example. As you may know, that officially IRS and OPR do not get involved in legislative matters. That's for the Treasury Department. But we hear what you have heard. We see what you have seen. We share those with the Treasury Department, and by interacting on what some of the challenges are in the practitioner community or in the taxpayer community, because there are unprepared and uncredentialed and maybe unprofessional practitioners or return preparers out there, the need for such legislation. Every time, and I don't know whether Jennifer is on this call or not. I'm not very good at seeing who's on the call while I'm talking. But every time I have run in either virtually or in person, Jennifer McMillan, since I came to OPR, her first question is, where is the revision of Circular 230? She knows that that's one of the things that I was hired to work on. And what I can say is it remains on the Treasury Department's priority guidance list. It's an area that I have spent a lot of time on. And I will say one more thing, that Secretary Yellen's and President Biden's, and I would guess new Commissioner Werfel's priorities don't necessarily wholly align with my personal ones. So stay tuned. We remain hopeful that a revision of Circular 230 will come out. And then just really briefly, and then I'm gonna make sure that we have plenty of time for questions. I think the very first document I signed as acting director was a letter to NAEA about trying to modify the digital signature requirements to facilitate the quicker filing of 2848s and 8821s without what the IRS would argue, and what the people who advise the IRS says we have to under federal standard, a digital signature versus an authenticated fax signature. And so that letter that we wrote in, I think it finally went out in February, was not what NEA was asking us to do. So this is one where we can have a candid exchange of views. We can share information and insights. We can think about ways that we might be able to work around an obstacle while satisfying our legal obligation, but we weren't able to get to where we could. And I'm sure that letter has been shared with all of you on the committee, and if not, I'll be happy to provide a copy to it. But the give and take, even if ultimately what we were able to give was less than what you wanted to take, I think is valuable. And then finally, in light of the provisions of the law with respect to the employee retention credit and a lot of the compliance and processing issues that arose, OPR has taken a step, and I was involved in meetings of the stakeholder liaison folks at the IRS that involved NAEA members as well as folks from other organizations, when we were able to deliver some guidance on what it means to be a tax professional for federal tax purposes, subject to Circular 230, subject to the circular's due diligence requirement. What does that mean in the context of an employee retention credit? And I think there may well have been some members who quite candidly were hoping that we would say something like, don't worry about it. You know, if you have a client who has already filed a bad claim for an employee retention credit, and they come to you with respect to something else. So they have filed that claim. Now they come to you with their tax return. The tax return reflects wages paid, but those wages paid have not been reduced by an amount equal to the retention credit. Can you sign that return? Do you have to dig into the return? And the way that we looked at, and quite candidly, the advice that I received, or the input I received from many tax professionals, was we know what we have to do. As difficult, as challenging, as expensive, when all of a sudden you have to tell the client, this is a lot worse for a lot of reasons than you think it is. One, you're not entitled to all of that credit. Even if we put that aside for a minute, you have to amend your 1040, or if you haven't filed your 1040, you have to make sure that it appropriately adjusts for the credits having been paid. So that was an example, I think, of good collective action, not only by NAEA and OPR, but other organizations as well. And it talks about how by keeping the lines of communication open, by staying involved, we can do it. Now, the rest of the slides.
And I'll just say, we do have time. We do have time to go over the rest of the slides, but because of the, we're doing pretty good with time, but because those few topics that you just mentioned were of interest to a lot of the folks on the call, I thought maybe we could pause, answer a few questions on those, and then you could run. Does that work? So
it works for me. Yeah, thanks, Steph. Good suggestion.
The first one I got, you sort of answered this, but I'm going to ask it anyway because you might have more. It says, when can we expect an updated Circular 230 to be released, and any hints about big changes we can expect?
So I don't think I'm at liberty to talk about the second question, and the first one is kind of my seat of the pants answer, which is the good news is during my tenure as acting director, I met with the commissioner once, and he asked me what the most important thing was for our office to be able to do it, and on the top of that list was a revision of Circular 230. He asked, what's the hang up here? And I said, look at the amount of legislation that has been passed during the last several years. The people at the Treasury Department have their hands full. So that was conversation number one. Conversation number two was in connection with the employee retention credit discussions, as NAEA did in its networking meetings with us, talked about the professionalism aspects of that. We were involved in the preparation of materials for senior Treasury Department officials that kind of said, what are the challenges? What have we done? What might we do in the future? And we indicated that quite candidly, that the fact that Circular 230 is as old as it is, that so many provisions of it cannot be enforced because of litigation, that certainly predates my time on it, that has somewhat of a diminishing effect on our stature. And that's not why an enrolled agent, right, advises their clients properly. That's not why people decide to cut corners or not cut corners, but we thought it was part of the whole. So the answer is that we are working on it. I have become aware that there has been, as the legislation goes forward, and the guidance on that regulations, that the Treasury Department Office of Tax Policy, where this resides, has kind of done a reallocation of who's assigned to what, and we are hopeful that the notice of proposed rulemaking will be issued soon. Hopeful, and $7 will get you a cup of coffee at Starbucks or another overpriced coffee shop, and but we remain hopeful and optimistic. I'm happy to say that we continue to have discussions with Treasury and with other parts of the IRS about the provision. You asked Pat about, well, what can we expect? Why changes? The only thing I think I will say, and it's not a surprise because we have taken this in our educational program, is it is most likely, just as the AICPA has recently changed its standards, and I think it's 40 or 41 states have changed their local bar rules, the Bar Association, that say explicitly that the competence requirements, so 1035 and Circular 230, that encompasses technological competence. And that really flows from the Security Summit and its recommendation that we all up our game. Other provisions, we think we're going to be improving. We're going to be removing ambiguities, and remain hopeful that what we will have is a good responsibility, as most of you know, this litigation, and mainly in 2014, there was one case in 2015 that a lot of people interpret as constricting significantly our obligation, not only, I mean, our ability or jurisdiction to impose continuing education requirements, which was the first case was about, and then also our ability maybe to sanction people who charge contingent fees, at least in certain circumstances, that those are going to, the draft that is being discussed right now, because that's the law we're dealing with, will reflect those changes. Anyway, hope that's informative.
No, that's very helpful. And you can't tell us an exact date or exactly what's in there, but that's very helpful color. So we've got a few questions on power of attorney, tax information authorizations, and CAF and that area. And the first one, we know OPR is over IRS Form 2848 and 8821 and the online power of attorney and tax information authorization. Can you explain what parts of the transcript request process OPR is over?
Yeah, great job. I don't think we are not over any aspects of the transfer request. What we're responsible for is making sure that the people who are submitting the request are eligible to do so, right? So we coordinate with CAF to make sure that the people who are listed on the 8821 or the 2841 or 8821, 2848, sorry, I'll get the number straight eventually, that those people are properly credentialed. And so we are responsible for that. And with that is an obligation with respect to making sure that there are not improper disclosures. So on the transfer request side, I don't think it's there. So you can, from the OPR page and from the tax pro account page, you can go to the request transcript part of the IRS, but we have no responsibility day to day on how that's administered. Other than passing along, sharing the frustration that so many practitioners have with the sometimes clunky nature and the delays that ensue.
So I'm going to ask a follow-up question to that. And I hear you sort of the bifurcation between what you guys are in charge of or not, but I think this touches on, your area. So I'm going to read this follow-up question. It says, currently we are not allowed to fax e-signature signed 2848 and 8821s. From what has been explained to us by IRS is that there are 3 questions about identity validation in the upload portal that need to be answered to accept the forms. And this suggestion has come up. I've heard this a couple times in the last few years. Would it be possible to add those questions to the existing 2848 or 8821 to allow faxing and possibly being able to submit multiple forms at one time? Example, if I'm uploading 20 forms to the upload portal, I have to ask the same questions over and over again to all 20 submissions, but I am able to fax 20 wet signature 2848s or 8821s to CAF.
Yeah. So no, and it is a great question. And so with respect to adding those questions, and I think this was actually the letter that Kathy Hennig sent that we responded to, and I just found it, I think, on February 23rd, which, by the way, was much later than it should have gone out to you guys because you submitted it earlier in 2022. That adding those questions does not resolve the issue, which is that we need a properly authenticated form, and so checking the box does not count by the people in our identity assurance branch, so the privacy governmental liaison part of the IRS works with identity assurance to make sure that we are protecting it. And this is the area where, I mean, another example that popped into my head is between with the employee retention credit, right? In that one, you have a statutory regime that Congress enacted in order to put hands in the money of people. And then you have a system that is slow to disperse those funds. But if you disperse them too quickly, fraudulent actors could take advantage of that. And in fact, there's been a fair amount of that. So this balance that you take between efficiency, allowing you to fax all of the forms at the same time, or at least if you're using the online portal to do it in a single transaction, which we have looked at, is something that we understand. You know, our view, our recommendation, our party line, if you will, which I realize is not perfect, is use Tax Pro account. But of course, as you all know, that requires your clients to have an online account and for your clients to respond when they get the prompt to do you approve this 2848 or 8821. So we looked at it. As I say, this is an area, and one of the things that I have learned over and over again since joining the government is everybody has a lane and everybody needs to stay in the lane. And sometimes that's why things take long, as we work our way through making sure everybody is heard. And it's because people whose primary responsibility is privacy and the protection of taxpayer confidential information, that the fix is not as easy as it might appear. And I'll be honest, when the letter came in from you guys, I look at it and I say at one level, why won't this work? And you know, one reason it doesn't work is because the level of authentication that takes place there, and even allowing you, the practitioner, to get online is not the same, right? Going to the fax machine and punching it in as even though we accept faxes, doctors accept faxes, all sorts of payment things affect taxes, but I mean accept faxes, but we are precluded by law, the way it's written now, from doing that in this area.
Thank you. And I will say that one of the priorities for NAEA is to work with the IRS on both CAF and the Tax Pro accounts to try to make them more user-friendly, more efficient, really with CAF to kind of rework the whole thing to make it more workable for tax professionals. And so to the extent that OPR is, has input or is involved in some of those issues, we would love to work with you guys as part of that process.
Well, no, and listen, I don't know if anybody on the call has had an opportunity to look at a very recent, I think, May 26th PICTA report, and PICTA looked at a lot of things that is coming out of the Taxpayer First Act and had some not particularly positive things to say about our promotion of the Tax Pro account. And so we are looking at different ways that we can contribute to that. Part of that is we are an interested party, but we're not an owner of the account. That belongs to our online services group. But in terms of how we can improve that and improve the CAF, because of concerns, and several years ago we were critiqued for having too many active CAF numbers for folks who not only aren't practicing anymore, they could well be incarcerated or they could well be deceased. And so efforts are made to fix that. One of the suggestions that was made early in the process, I don't think I'm talking lessons in school, was you should require everybody to get a CAF before they file their very first 2848 and 8821. So you have a client that shows up to your door today and says, I have a meeting with an agent tomorrow, I'd like you to go with me. And you go, okay, I need you to sign this 2848, the 2848, but you don't have a CAF number yet. Now, what you do now, if it's blank, you leave it blank, you fax it to the agent on the call or the person across the table from you, and you can be done. And so OPR's comments and other people in the service echoed it was, you don't want to inhibit a taxpayer's ability to have a representative of their choice available to help them do it. But we are continuing to work on it. It is, I know we're going to roll out, the service is going to roll out a new iteration of Tax Pro account. I know, I think it's all of next week, Tuesday, Wednesday, and Thursday of next week. I'm going to be involved in user testing on some of the new features, where we listen to practitioners as they walk through what we think is an improved system, and then make appropriate tweaks. But it would be fantastic to continue to work with NAEA on both the CAF aspects of it and the and then just the 28, 40, 48 and 88, 21s in particular. There's got to be a way to improve it. You can't always blame. You used to say, hey, if you're new to a place, I'm relatively new to OPR, just blame your predecessor, right? And that doesn't get the problem solved. So I don't want to say, hey, we have antiquated technology. In going back to the ERC for a second, we do permit people to fax the 941s in claiming those things. But you know what we can't do with our current technology? Scan them. So they all have to be manually entered into the system. I mean, that's kind of a mind-blowing, well, why can't you do it? It says, well, because it's old technology. Someday soon, we may get there, but we continue to look at ways to deliver a better product more quickly, especially to an important partner like an old agent community. So.
No, we appreciate that. And we'll definitely take you up on that. The next question, it jumps ahead to a future slide, but it's on the Tax Pro account topic. So I'll just go ahead and ask. It says on slide 15, the Tax Pro account see all authorizations feature is mentioned. Is there a possible release date of this feature, the see all authorizations feature?
No, excellent question. And that is the one that, knock wood, subject to user training, user testing, will be released by the end of summer. Certainly it's on the schedule I saw was, boy, we'd like to release this in July. We know it likely won't be ready for the nationwide tax forms. I mean, we're disappointed by that. That was what the aim for, but by the end of the fiscal year, so that's September 30, it should be out there and ready to use.
Okay.
But yeah, good question.
No, that's helpful. All right, there's one other question, then I'm going to let you get back to some of your highlights if you want. Does OPR have any oversight on WISP? And can the new Circular 230 include questions prompts to help smaller 1 to 5 person firms to comply with this requirement more easily?
I'm sorry, what requirement was that?
The WISP is the Written Information Security Plan. WISP.
So let me answer the second question, which is we got to figure out a way to do that. We in my presentations, I usually talk about the security plan being kind of at a high level, being part of the responsibility under either 10.36, the procedures to ensure compliance, or just the competence. So we mention it at that level and usually leave, and this is the case if you look at the sessions for the tax forms coming up, that other folks are handling that. But I think the suggestion of trying to figure out some type of a checklist or an algorithm or whatever the appropriate word is that would allow smaller practices to work their way through that. I've been scribbling a note here, and I will try to raise that with the folks who are responsible for that currently. And this is a holdover, but I've been asked to continue it. I am OPR's representative on the security summit. And so we're talking about different ways. I have to admit, and obviously asking what the acronym stood for betrays my lack of experience in this area, that when I spoke to the AICPA, a year. I mean, there were more questions about that and what that meant than almost anything else. And the interesting thing is, and this goes back to, if you will, what does due diligence mean in the context of the ERC? It is what it is, even though what it is stinks, is that people said, hey, I hear you, but there's no way you can cut short your obligation to safeguard that client information. And that's really what the requirements coming out of the security summit are all like. But let me, as I say, I think a way to kind of say, what do you have to do? Because what that document out of the security summit, I can't remember the publication number, it is a long document. You kind of say, how does this apply to me? And we ought to be able to work collaboratively to provide guidance, especially to the smaller firms, but to everybody on how they can more than just metaphorically check that box.
You've mentioned ERTC a few times in the guidance that you guys put out, and it's obviously, you know, all of the fraud that's been happening and the mills that are out there has been a big story, as well as sort of the delays and some businesses that are waiting for their, you know, credits has been a big story. I know that there's a big sort of audit ramping up in terms of they're training a lot of folks to sort of audit the amended 941s and whether the credits were claimed correctly. In terms of Circular 230, has there been activity in that front of enforcing, and I don't know if you're allowed to comment on this, but has there been an uptick on enforcement actions related to ERC?
Well, no, you know, and I will, again, I don't think I'm telling you. When I met with the commissioner, he said, what are you doing about the guys who are part of the problem? Yep. And so, and I don't think it's mentioned in the slide, so it's part of the disciplinary process. We usually don't get involved in a case about a practitioner until the associated taxpayer case is done. There may be some exceptions. So, for example, in a case involving an appraiser, there may well be action taken depending on the referral we receive, usually internally, about that. So from a standpoint of, do we have anything in our inventory? The last time I checked, the answer is no, and it's not a surprise to anybody because of the sequencing that takes place in that. On the other hand, and so this is I'm sure all of you have got, or most of you have, some frustrated clients out there. I'm happy to say, I got a list overnight of kind of the current numbers. Is that, if you're in the 1%, you're not going to like it, but there's only 1% backlog. 1% of the claims currently are more than 90 days old. Last week we received 32,000 claims, and we closed 126,000. So we are chipping away at the backlog, which is now about 400,000 claims. With respect to the enforcement activity, there has been that ramping up on there was a story in, can't remember whether it was
Wall Street Journal, maybe there was a Wall Street Journal article, I know.
But in terms of where the IRS is focusing its, if you will, its fiercest attention, and they tend to be with quite candid, the folks who have nothing at all to do with the tax profession, right? The folks who are making up employers and then selling. Most interesting call I've had about this, because it was just completely out of the blue, which is I got a call one day from someone in the Consumer Protection Branch of a state attorney general's office saying, I'm getting complaints from citizens in my state who have been taken for a ride by a promoter. And what are you guys going to do about it? And I won't say we were able to do anything about it, other than I knew that wasn't within my bailiwick. And I forwarded that to our ERC task force that I happen to be a member of, but which went to the Office of Promoter Investigation and the and the criminal investigation part of the service. And then it's slowly working its way through wage and investment and SBSE. So right now, the most current count I saw is there are about, I think it's 6,000 audits that are underway. I take that back. 4,000 audits that are underway, 2,000 that are being evaluated, dealing with ERC claims. And OPR will look at whether or not we have Circular 230 practitioners involved in that. And my guess is there will be very few that fall within our jurisdiction.
Yep. That makes sense. Well, we've got about 4 minutes left. I don't know if you have any sort of highlights from the slides you didn't get to that you wanted to hit on to close things out.
It flows from the discussion we just had about ERC in enforcement and stuff. And so this is the, and in my prior lives, both with the association, with the Big Four firm, I spoke to a lot of groups about tax ethics and professionalism and things of that sort. And I do a lot of that now with OPR. And my answer is, if you're in the room hearing my presentation, you don't have anything to worry about with OPR. The statistic that surprised me the most, and because I guess I hadn't thought about it, is, of all the referrals we get in a given year, we get them internally and externally. And most of the external ones come from CPA societies or from bar associations, but we get some from some practitioners about sometimes it's former colleagues, sometimes it's about competitors. But the of all of those cases we receive, we don't take action in more than 90% of them. And in a way, that should provide you guys comfort. One, people are saying, hey, this is inappropriate conduct by somebody. And we have to say, are they a practitioner? Was it a violation of the circular? Was it an important violation of the circular, meaning is it a one-off or not? And then what's the appropriate sanction? So it's a winnowing down of the cases that go forward. And so, for example, I think I've only signed 4 disciplinary, during the time I was acting director, only 4 disciplinary letters. I signed other things too that related to cases, but in terms of, we are done with this process. If you don't like what we've done, you're going to have to appeal to the administrative law judge. And so the last comment I would say is, we are here as a resource for the tax community, and that includes NAEA members who are doing the right thing. I'm confident that all of you who are on the call are doing the right thing. So you can listen to me without fear in your heart over we're going to be coming after you. We know that we have an awesome power, not like, hey, awesome, but awesome meaning very, very significant. Because if we suspend you, you can't do your job. You can't do what you want to do for the clients you want to do it for. On the other hand, that's why we want to get bad actors, people who are truly not fit for practice, out of the system. At a time when it is not easy being a tax professional, as I say, it's something we take very seriously. Not to be too quick on the trigger. On the other hand, it is something that concerns me. And then one last thing, because I was aware of this, but not aware of how significant it is. I don't know how it is with EAs. I know for accountants, the number one thing that are cited in ethics opinions about accountants, the number one is that they don't satisfy their CPE requirement. Now, that's not because that's why they came to the attention of the authorities. The number one thing that we cite in our opinions is the tax professional doesn't satisfy their own tax obligation. And that's because every single case we get, even those that we dismiss because it's not the violation, the conduct violation doesn't come within our jurisdiction, Did you file your tax returns? Did you pay what you did? If you willfully did either one of those things or didn't do one of those things, we're gonna be more than just tapping on your shoulder. We're likely gonna be talking with you about a reprimand or a suspension of some period of time. And I don't want to keep people over.
So the message is pay your taxes if you're an EA or anyone, right?
So I think anyone, but I listen, I appreciate the opportunity to be with you. I know, Thad, because we communicated on other things, you have my email address. Feel free to share it with the people on the call. If they have a question, they want to follow up with me. In a lot of cases, I will find somebody who knows more about it than I do, and we will get back to you.
Really appreciate it. Thanks for taking the time. Enjoy Maine, and have a great Father's Day and weekend.
Hey, thank you so much. You too. Bye-bye.
All right. Take care. Thank you.